Good afternoon, everyone. Allison Scoberg here, Consolidated Planning Group, and today we are talking with attorney Mike Day on the topic of special needs divorce. So a couple of things from a housekeeping perspective. Your cameras and your microphones are muted, but we know you're there and we're glad you're here. We want to take as many questions as possible. So if you'll just put your questions in the chat box, I'm going to be monitoring the chat box today, and we'll be reading those questions out to Mike. Our hope today is that this meeting is going to be a little bit more conversational in nature. I know if you're here, you're either in the throes of divorce, contemplating divorce, or you're in kind of maybe a yucky space in your life right now, or challenging at the very least. So we do understand, and we are glad you're here. There's a lot of things certainly to consider when it comes to divorce in general. But when you have a special needs child that may have care needs for the rest of their life, not just yours, there's a whole kind of other, another way of thinking about things. So Mike is here from the Jenkins and Kamen family law practice, and they're in the greater Houston area. And Mike has a lot of experience in special needs divorce. And one thing that I want to say that I think is important, I know that like when people are going through a divorce, Mike, they're drinking from the fire hose. There's a lot of things coming all at once, plus your full-time job as a parent and your full-time job and all the other things, all the other many hats that we're wearing. But when it comes to divorce with special needs, I think that it's pretty important that you're either working with a divorce attorney that is nuanced in special needs and understands the law as it relates to special needs and some things that might need to happen in your divorce. Or if you're already working with a divorce attorney that has no background in special needs, that you partner with somebody else that will kind of consult or work with your attorney, so that way things can be set up properly. So anyway, we're excited to be here with you today, Mike. I do want to wish everybody a happy belated Mother's Day. I hope it was a wonderful weekend. Man, I was thinking yesterday, if it's this hot in the first week of May, I can only imagine how hot it's going to be coming up soon, for sure. But I hope everybody did have a relaxing and wonderful Mother's Day. So having said that, we'll be done by 1 o'clock today. So if you're planning your calendar, it's from 12 to 1, and this is being recorded. So later today, you do not have to write down every single thing in these slides. You will get an email later today with a copy of today's slides, as well as a copy of the recording and all of our contact information as well. Okay, so I'm going to turn it over to you, Mike.
Thank you, Allison. And first of all, thank you for letting me present this webinar with you today. It's a real honor. We have a very knowledgeable group when it comes to special needs planning, and thank you very much for having me. And also, happy belated Mother's Day to all the mothers in the audience. So before we get started about the nuances of special needs divorces, and when I say that, I'm talking about a divorce where you have a child who's already transitioned into adulthood or is getting ready to transition to adulthood, and that child has certain disabilities as defined by the law. Before we get into how those types of divorces are different, let's talk about how the divorce is kind of the same, whether it has a special needs component or not. First of all, if you're going through a divorce or you're contemplating going through a divorce, know that you're not alone. This happens to a lot of people. Don't beat yourself up. Don't allow yourself to be overwhelmed with shame or despair or anything like that, because this is a very tough process, and you're going to need to have self-compassion and engage in self-care, and know that before you can do your best, you have to really kind of take care of yourself, because what I call cortisol brain is very real, and it prevents you from being the best version of yourself, and it prevents you from being able to make the best kinds of decisions and engage in the best kind of decision-making process. So you really have to address that. And you also have to know that, not all divorces are traumatic and not all divorces result from traumatic events, but a lot do. And betrayal trauma is very real. And if you are engaging in that, if you're having to go through that process, just make sure that it's especially important for you to take care of yourself and make sure you have a therapist that understands betrayal trauma that can help you get through that process, because there are definitely best practices to help you get through betrayal trauma. I say get through, and maybe a better way to put that is to process it and integrate it to where it stops giving you so much cortisol. And lastly,
Hey, Mike, that's really a great point. One thing I would like to mention, if you guys haven't looked this up, there are divorce care support groups all across the area, all across the country. It's not just here. And a lot of the ones, they're usually out of a church, but a lot of them have a divorce care for kids also. Some of them have divorce care for special needs. So you might want to look that up. That is a good program. It's a good program for the whole family. So that is something. But this whole self-care and kind of, everybody puts their kids first, but this is true in all families that have special needs kids, whether going through divorce or not. A lot of times we put ourselves, as parents, we put ourselves on the back burner. And when we're kind of, running the marathon, not the sprint. And what I mean by that is when we have kids that are going to be with us forever, right? It is critically important, not just through divorce, that we look at this. So this is such a great point.
Yeah, I would like to say most people put their kids first. Not everybody does. And those are the cases that are especially problematic. And I would also just kind of add to that sometimes people have fundamentally incompatible notions of what it looks like to put your kids first. And that's one of the things you'll find going through a divorce is, for lack of a better term, it's almost like it's an existential process, because it forces you to be very mindful and intentional, at least most of the time, about your values. And, your values should inform how you go through this process. And for most people, their values consist of putting their kids first. But just be mindful of that. I would say that that's also very important. But bearing in mind and how divorce with or without the special needs component can be, let's talk about what makes it different. And one of the areas where it's really, really different is that you need to have an interdisciplinary team. And you need to have an interdisciplinary team because if you're going to put the kids first, one of the things that you need to make sure that you do is figure out a way to financially make that happen. And each family is different. Each child is different. And so that's why you need a financial planner. That's why you need an estate planning attorney, and not just any old estate planning attorney that can draft a will for you. You need an attorney that is very knowledgeable about special needs planning. And this is especially true in the state of Texas, because in Texas, you have just a complete and total maze of governmental benefits and hoops that parents have to jump through that you don't necessarily have in other states. But it is a reality for special needs families in Texas. And so you need to, one of the first things, if you're going to go through this process, or if you're going through this process right now and the process is not concluded, is to make sure that you have a good special needs planning attorney on your side. And you also probably should have a special needs financial planner on your side as well, because the financial planner can do things for you that the attorney necessarily can't. And the attorney is the only person who can really do things like, say, draft a trust. And as we'll go through the slides, we'll talk about that. But having what's called a special needs trust is very, very important in these sorts of cases. And lastly, having a medical team be available to you. Being a lawyer who has done a lot of divorce litigation and has taken a fair amount of cases to trial, I would say that sometimes people dispute whether or not the child is disabled. And sometimes, and we'll get to what that means, but I mean, just know that you need somebody in your corner, whether it's a psychologist or some other sort of medical discipline, that can help you, how should I put this, make sure that you've got the best evidence that you need. Because your lawyer helps you with presenting the case, whether it's presenting the case to your spouse and the spouse's lawyer, or God forbid, you have to present it to a judge. But the expert is the one who's going to actually be providing the testimony in addition to the parents. And so it's very important, if necessary, in particular, if somebody is either disputing that a disability exists or is disputing not so much the disability, but the care of the disability, right? Because sometimes parents disagree on what the best practices are for the care. And you may need an expert that's willing to testify as to what those best practices are. And so once you have your values put together and you know what your value is going to be, whether it's putting the kids first or there are other considerations, and then you have your special needs planning team in place, because they sort of really help you with the most fundamental decisions. And then the divorce lawyer or the family law attorney will help you work backwards further from that, because somebody like me needs to know what kind of trust needs to be put into place. If there are going to be multiple trusts, for example, if there's going to be a guardianship in the future, or if there's already a guardianship, and making sure that there are not conflicting orders coming out of the family court and the probate court that handle the guardianship. But that's
Mike, you hit on a couple of things that I think that there's a lot of confusion with the general public, and I just wanted to clarify. So the special needs planning attorney, so you've got a divorce attorney and a special needs planning attorney, and there may be divorce attorneys that are nuanced in special needs. They understand special needs, but that doesn't mean that they draft special needs trust and do guardianship. They typically don't. So oftentimes when it comes to drafting documents, I always say, because people call us all the time asking for documents and things like that, the special needs planning attorney, that's your guardianship, your wills, your power of attorney, your healthcare power of attorney, all those special needs trust, first party, third party, those types of things. And we're the money, okay? So they're the paper, they're the legal documents, you basically gotta have them, but we're the money, we're the funding, we're the future care cost estimate. What is the future care cost that we think is going to, it's gonna take to fund the future care for your loved one with special needs? So the team is important, but this is where I want to ask Mike, for a lot of people on here, they probably already hired an attorney, and they hired the attorney because they like the attorney. And so this is not where they necessarily have to ball everything up and start over, but this is where they're getting maybe strategic partners on their team that is partnering with their divorce attorney that they've hired. Is that right?
That's correct. I mean, you're going to need certain specific findings in all likelihood in your divorce decree with respect to getting child support beyond 18 for the child, and also making sure that the way those payments are structured, they're structured in a way that does not jeopardize governmental benefits going forward. And that's why it's so important for the family law attorney and special needs planning attorney to really be on the same page. Because the special needs planning attorney is going to say, look, we're going to, for example, child support, it's got to go into Medicaid payback trust. That's considered a first party trust, right? But a special needs planning attorney could also maybe come up with some other trusts where the money doesn't necessarily have to all go to the federal government, right? So, the child with special needs is taken care of during that child's life. And then, God forbid something happens, well, the remainder of the money doesn't have to go back to the federal government. Right. That's why maybe you would want to have multiple trusts. Now, I say that just because I have an understanding of that. I don't draft those types of trusts. And I'm a board certified attorney in Houston. I used to serve on the board of directors of the family law section of the Houston Bar Association. And I know a lot of the attorneys in town. And I know some very good family law attorneys that work in the special needs arena, but I can't think of a single one that has any business drafting a special needs trust. Okay, that's not.
Yeah, and that's where that confusion comes, as we think of an attorney and he's nuanced in special needs, and maybe he can just do everything. And it just doesn't really work like that. It's just like what we do as a financial advisor. There's a million financial advisors. There's very, very few that have any nuances at all regarding special needs. But you hit a topic that I want to kind of expand on, because that is one of the biggest things that come up in our practice that we hear about when people are going through a divorce is, they know that, Texas is a 50-50 state. They've heard of such things as unequal distributions in the case of special needs. They've heard of child support continuing post age 18. They've heard of some of these things. And then maybe if they're lucky, they've heard that the child support does need to be redirected to a first party special needs trust, at least by the time the kid turns 18, because otherwise, when you go to apply for SSI and Medicaid, they're going to deem that child support against the child as income. So that's the why behind it, because a lot of times, we're good at saying, what needs to happen, but the reason why it needs to happen is not always clear. And so what I would say from my perspective, and looking at, clients that have gone through this, it is so much better to get things right the first time. When you get up to bat, when you get in front of that judge, or you get whether it's mediation or whatever you've got going on, to have things set up and teed up correctly on the front end, so that way you don't have to go back to the well, if you will. So can you comment on that, Mike?
Sure. Yeah. Measure twice, cut once, always. If you can get so from a drafting standpoint, you need certain findings in the divorce decree, and then you want to have the trust, the child support to be ordered into the trust. And you need to have an important conversation with your special needs planning attorney as whether or not that trust actually needs to be an exhibit to your divorce decree. But yes, I mean, in terms of not doing things, I don't want to say, let me put it this way. I mean, this is an easy area to screw up. And if you screw it up on the first go around, it's a lot more expensive and time consuming to fix it on the back end. I'm aware of a case that went to trial, went to the Court of Appeals. It's not a case I was involved in. It's just a case I know about. And in that case, I mean, the child was in graduate school, but was still considered disabled under the statute because the child was not self-supported. However, the child support was not being paid into a special needs trust. And because the child support amount was so high, the child was not qualified for governmental benefits. And then the trial judge said, well, you need to do what you can, Mom, to get this child qualified for benefits. So, the mom tried. It didn't work out because there was too much of child support. Child support wasn't going into a special needs trust. Then it goes up on the Court of Appeals. Court of Appeals says, yeah, child's disabled, and Dad, you still have to pay X amount of child support. And she's not on the court anymore, but one of the few former family court judges to be on the Texas Supreme Court, Eva Guzman, she said, well, the outcome is fine, but man, the statute needs a lot of work. But as a lawyer who's done a lot of this work, what I got in the back of my mind was, well, why on earth didn't they just have the child support go to a special needs trust in the first place, right? Because if that had happened, then you wouldn't have to worry about whether or not the child was going to be eligible for governmental benefits. And so you had a case that almost went up to the Texas Supreme Court, when in fact, some of the real fundamental nuts and bolts type of work was not done on the front end. And it was just kind of unfortunate. And
that's some of the stuff that we're seeing when you're working with a divorce attorney that has zero background in special needs, and you've maybe not done this before, and you don't even know what to ask. You just hire the professional, and you think they know what they know and that they're going to have everything handled. So I think that is an issue. But one thing, when we're talking about government benefits, a lot of families have never qualified. Their kid has never qualified for government benefits. And they don't even know what we're talking about because they were denied SSI and Medicaid because their family made too much money. But when your child turns 18, we have entire webinars on this. your child, depending on their disability, is likely eligible for SSI and Medicaid. And right now, SSI is $841 a month, and it comes with Medicaid. But this is where we're talking about the child support being counted as their income if it's not going to a first-party special needs trust. So that's why it is so important. And we know that there's a lot of confusion with that. But again, we have whole, webinars on SSI and Medicaid. But the first-party special needs trust is important for that reason. So thank you for sharing that and kind of going a little bit deeper.
Yeah. So
let's talk about a disabled child. What constitutes a disabled child in the eyes of Texas?
Okay, so for purposes of Texas state law, which is a little different from the federal government standard, because that goes all the way up to 22, right? But this is, you have to have the cause of the disability known to have existed prior to the child's 18th birthday. And I won't read the slide here. Everyone can read that for themselves, but this is the statutory definition. So if you're going to try to get child support beyond the age of 18, okay, then you must have this fund. You can't agree. Well, let me rephrase. There is an argument to be made that you can't agree to have some sort of contract for support beyond the age of 18 if you were not to have this fund. I would tell you, though, to try to avoid that, because there are some cases, they don't involve children with special needs, but there are a couple of cases that have come out of Dallas. One was about tuition at Hockaday. One was about tuition at another private school where the folks had contracts, and the Court of Appeals basically disagreed with the trial court and voided those contracts and said that if you have a parenting plan, that cannot be enforced by a breach of contract lawsuit. And what almost all lawyers do not know is that at the end of Section 154, which is the child support statute, in particular the part that deals with children with special needs or an adult disabled child, you arguably have the ability to have a contract. But there's no, the one thing I will say about this statute is that there are a lot of gray areas, and these cases are seldom tried, and when they're tried, they generally don't go up on appeal. So the lawyers don't necessarily have case law to say, this is what this case means, or this is what this statute means, right? You just don't have a lot of that. And that's just sort of a function of the law, right? It's somewhere like 5 to 10% of cases go to trial. And Allison, in a moment, I'll talk about how to avoid being part of that unlucky percentage. But of those 5 to 10% of cases that go to trial, not a meaningful percentage of those cases go up on appeal, right? It's either for any number of reasons, right? And so when you think about it, whether you're a lawyer or not, it's pretty astounding that something like anywhere from 2% to 0.5% of all cases that get filed in Texas drive how the law is interpreted. I mean, because you think about it, and those are generally going to be the most extraordinary cases, certainly the most quarrelsome, I'd say. I mean, I don't mean to minimize it, but the cases where people have the biggest fundamental disagreements about that quarrelsome has a negative connotation.
We have a question that I'm going to read in just a moment, but I also wanted to comment when we were talking about child support earlier. One thing that we've come across in our practice here is in the event that you're already divorced, you've got court-ordered child support, but the person is not paying what they're supposed to pay, or they're paying less, it's still counted against you. So it still needs to be redirected, or there needs to be some court action throwing it out or whatever it needs to happen if you don't have that special needs trust. We had a family where it was grandparents who had guardianship of the grandchild, and then there was a child support that was supposed to be being paid, and it wasn't going to them, it was convoluted, but the bottom line is it was still going to be counted against them for benefit purposes. But we did have a question, and basically it was this situation where they've been divorced for a long time. There was a standard possession order. Non-custodial parent left country and has been violating that the past 6 years. There's been substantial expenses as a result of all of that, raising 2 special needs kids. Is there a such thing, or is there a way to go back for retroactive child support to make up for all the time and expenses that the parent has been absent? Is that a thing?
Generally speaking, I mean, there is a way to go back for unpaid support. I draw, if you're just looking at child support that's not been paid, you'd have to look to the terms of the underlying divorce decree to see if there was a disability finding and if there was an obligation to pay child support beyond the age of 18. If the issue is medical support, then the question is, did the parent who is getting all the medical support for the child comply with all the, conditions of that in terms of, promptly sending out the EOPs and stuff like that. And then that will be kind of a case by case situation. The one thing I will say is that even if something's not enforceable by contempt, which means you throw them in jail, you still might be able to have a way to get a judgment. And a very, very interesting change in the law effective 2021 is that you can now explicitly under Texas law get a qualified domestic relations order or a quadro for purposes of collecting child support. And this is huge. I mean, this is absolutely huge because in other states you were able to get it. And I always thought that under the plain reading of ERISA, you should be able to get it. The Supreme Court had a case called Dalton versus Dalton, which arguably said that my reading and most other jurisdictions' reading of ERISA is incorrect, but the legislature, thank goodness, has corrected that. And so what a quadro does is it basically allows you to garnish somebody's 401k, which is pretty extraordinary. Because if you think about it, most people, even very successful professionals, they're largely going to be judgment proof, right? They have their homestead and they have their 401k. Maybe they have a brokerage account that would be subject to garnishment, subject to execution of a judgment. But being able to get a quadro for child support purposes is a potential game changer for someone in the right situation. And if in reference to the question from the audience member, if the other parent is living abroad, then that becomes a more nuanced area. There is an international treaty that governs international child support collections. And so you'd have to look to see where that other parent was living. In addition to that, even you would also have to see if that parent who was living abroad had meaningful property interests in Texas, or at least somewhere in the United States, because it's one thing to get a judgment, but if you're not able to collect on that judgment, then you really have to ask yourself why it's so important for you to get the judgment. And you never know. There can be collateral consequences not paying a child support judgment, especially if somebody's a licensed professional or something like that. So, I mean, it could be to that parent's best interest to get a judgment against the person who hasn't been supporting their child. It's hard to answer that.
It can also be a fruitless, expensive effort because you can't get blood out of a turnip, and you're going to pay attorney's fees, and you're going to have to hold them in contempt of court and go after them, and you still might not get anything. So and then there's the stress that's involved with that on top of your normal life and stress. And so it's kind of that balance on whether or not it is worth it. So we do have a question, and this is a great question and a great segue into if there is a good divorce, or, obviously the less you stay out of, the more you stay out of the courtroom, the less legal bills you're going to be spending, the shorter the period, there's a lot to be said from staying out of a courtroom and not like fighting. And some people don't have that option. It's just not optional. But for the families that are just trying to really put the best interests of the kids at heart, and they're able to get to a point where they could go to a mediator, we have people ask us these questions too, like, what are the main things that we should include with the mediator? So the one thing is the child support being redirected to a first party special needs trust. I also suggest life insurance on both parents. So because if something happens to either one of you, your income dies with you. So your ability to support the child, or the ability to carry out the plan, is altered. So typically having life insurance on the life of each of the parents with the third party special needs trust as a beneficiary for that plan, which will fund the future care for the child, that is something else that we recommend that happens on the front end. Trying to get that on the back end is like not happening. It's hard. It's not impossible, but it's really hard. But I think if we're at a mediator table, so the child support redirected, the life insurance, are there some other things that you think should be on the table or up for discussion? You got two people that are trying to settle things out, not fight, not trying to stick it to anybody. We just want it to be fair. What else do you suggest?
Well, I suggest that the parents, even though they're getting a divorce, they are transparent about their estate plan. So, and this is a great example of why it's important to have a lawyer who has some experience with special needs divorce, because a lot of times people will put in language that someone's going to have carry a life insurance obligation to discharge the child support obligation of the estate. And they have to maintain that they have to maintain that life insurance policy as quote unquote additional child support. Now, people include that language because they want to make sure there's money there in case the income stream, passes as a result of death. But then that creates some sort of nuanced questions, because if it's done as a form of additional child support, then you need your special needs estate planning attorney to say, well, if the life insurance is going to be a form of additional child support, does that need to go into a third party or a first party trust, right? I mean, that's a nuanced question. And then secondarily, if it's not going to be a form of additional child support, if it's just going to be a matter of contractual support, which, one reading of the statute certainly allows, then maybe that could go into a third party trust. The other thing is that the federal government recently passed a law called the Secure Act, and it's pretty brand new. It hasn't really been interpreted that I'm aware of. And I looked into all this last week as it pertains to the subject matter of today's presentation. But what the Secure Act enables somebody to do is to fund a trust with their 401k. And so it stands to reason, if you could fund a trust with a 401k, then potentially you could be allowed to fund a special needs trust with a 401k. And so making how that happens, right? Because if you don't have, very specific language, normally a divorce sort of eliminates the other spouse's ability to collect or to compel any kind of distribution from the 401k, absent some language to the contrary, right? Because the law normally is, well, if you get a divorce, then your ex-spouse cannot be a beneficiary under your will, and it does some things potentially under ERISA and that sort of thing. So you just have to, there are different ways to coordinate that. The other thing I would say is, if the child is about to turn 18 or is already 18, you might want to go ahead and talk about possession and access, and talk about whatever needs to happen for purposes of the guardianship proceeding. And if there's going to be a guardianship proceeding, and then you need to coordinate with guardianship counsel. And I know that sounds like a lot of lawyers, right? But if you think about it, if you go to the hospital to get a procedure done on a broken bone, you got a radiologist, got an anesthesiologist, and then you have the surgeon, right? Now you're just sitting to yourself, well, I'm going to go to the hospital and get one stop place. But there are lots of different professionals along the way, and they all have very different disciplines. And just like an anesthesiologist isn't a surgeon, lawyers have different functions as well.
So on that, let's talk about that for a second. So when we're talking about this, and I agree with this. So if you have a child that has a disability, just general rule of thumb, IQ 70 or below, if it's definitive that that the child's going to need guardianship, then I think that these conversations are definitely necessary on the front end. Whether it's mediation or whether it's in your documents that are court ordered or what have you, I think that that's very important, and it's something that's forgotten when we have kids that are, nowhere close to being 18. We're not thinking about guardianship at that time, but it definitely does. It definitely does come around. So one thing though that you mentioned, Mike, I want to say when it comes to life insurance proceeds, it is definitive our best practice that those life insurance proceeds would go to a third party special needs trust, not a first party. So, I mean, obviously, if a judge deems it as child support, you can't help but have it go to a first party special needs trust. But I want to be clear, the third party special needs trust does not have a Medicaid payback, and a first party special needs trust does. And usually families that are funding their trust with life insurance, these are large policies. They might be several $1 million. So I think it really careful consideration for that matters. And as a best practice, those large life insurance policies directed to a third party special needs trust is a best practice because there's no Medicaid payback.
I certainly don't disagree with that. I guess my point is that it's pretty common in divorce decrees, in particular with children who do not have special needs or who are not going to satisfy the adult disabled child statute, to have a life insurance that's going to cover the obligation of what the law calls for obligor, the person who needs to pay the child support. Their state's child support obligation is going to be funded by the life insurance policy, and the obligation to maintain that life insurance policy there's a little term there. It says as additional child support. And most lawyers or I'll say a lot of lawyers who may not be super familiar with some of these nuances, will be like, oh yeah, of course you want to put that language in there. And that's, if you want to put that language in there, you just informed consent is the name of the game, right? So you want to make sure that if the obligation to maintain the life insurance policy is additional child support, you just want to make sure you're not tripping yourself up with where that money, God forbid something happens, where that policy money actually ends up, is my point.
Now, what do you think? Now, this is something that we've done in the past too. So we've seen it where there's a court order for someone to pay it, but we've also seen the court orders violated to where they weren't paying it. And we already talked about contempt and all the other stuff, and that kind of hamster wheel. We've also, where people were doing mediation, they agreed to the life insurance. It wasn't considered child support, and each other was the owner and the payer of the other policy. So they all signed up for it, and the ex pays for hers and is the owner and the beneficiary and controls the policy. He sees himself that this is paid, and then she is the owner and payer of his. She has a vested interest to keep it paid, and nobody ever has to go back to court for contempt. And so if the other person doesn't pay it, well, if one person doesn't pay it, it affects them directly, if the person passes away. So we've definitely seen that as an option as well. We have another question. If a special needs child requires monthly non-prescription medications for diagnosed chronic conditions and adaptive equipment for physical therapy denied by Medicaid, does that count as an out-of-pocket medical expense where both parents are splitting medical expenses?
It depends. You have to look at how that term is defined in the divorce decree, if it is defined. And there's a slide that speaks to this later on, but I'll go ahead and address it. So there's this document called the Family Law Practice Manual, and it's sort of the Bible for the family law bar when it comes to drafting divorce decrees. It's considered to be best practices, and it's a wonderful document. It's a result of hundreds of hours of painstaking work done by other family law attorneys throughout the state of Texas for free, right? And it's if you go to mediation, and the mediated settlement agreement calls for X, Y, and Z. And then the parties disagree as to how, because a lot of times mediation, it's almost like a back of the envelope type deal, right? And so you'll say X, Y, and Z, but really you're representing all the letters of the alphabet. What order are you going to put them in, right? And so sometimes people disagree as to what that really means. And so it's very common to allow the family law practice manual to govern those drafting disputes. And as wonderful as the family law practice manual is, and as wonderful as the work that all those lawyers who work on it, they do that work, for the benefit of the community. Sometimes those provisions are not great for families with children with special needs. And a lot of it has to do with, like, for example, if you go out of network, right, and you make the decision to do that, then sometimes you're just tasked with paying 100% of it, even because that's just sort of the default position. So there are a couple of situations like that that are sort of the standard language, right? And it would behoove a lot of people to go in mediation and to have those terms expressly laid out. And if they're going to be different from the family law practice manual, they go ahead and say that. Because if you don't have something different going in on the front end, then you are potentially at risk of the mediator saying, yeah, I'm just going to go with what the family law practice manual says. And the same is true with the judge, right? I mean, if you, because the judges are going to frequently, defer to that as well, because that's just what people in the family bar do. It's just considered best practices. And, a lot of mediators now are starting to put in their agreements, the family law practice manual will govern as appropriate, right? But then people start arguing about, well, when is it appropriate and when is it not? And so that's why it's better to just go in with part of your proposed parenting plan and say, I want X, Y, and Z covered, right? And so I don't know if I answered the audience member's specific question, but again, it's going to be a function of how that term is defined in the divorce decree.
Thank you. I have one other question. I know that we're getting ready to talk about, we know that there's a child support guideline, and then there's, we've definitely seen above the child support guideline for child support when there are special needs. But let's talk about, for anybody that's already divorced, they already have their decree, and one parent was going to pay the medical insurance, and then the parent loses their job, and the job was the provider of the group health insurance. Well, these families have serious needs. Their kids have disabilities, so not having health insurance is really not on the radar. Do you have any suggestions for rectifying a situation promptly in the event that happens? I understand COBRA, but most of the time when people have lost a job, they can't afford the COBRA premiums. They're ridiculously expensive, right?
Right.
So what do you do? I mean, so, they go back to court and alter the child support and say, okay, just kidding, you don't have to pay for medical, or what happens in this example, and how can they move promptly?
Well, I would say that the best way to approach that is if you already have a solution in mind. So whether or not it's going to go with a different health insurance plan or what have you, you could do one or two things. You could just agree to do that and then see if that plays out. If there's a not the requisite trust to do that, then you can go to mediation before you even file a lawsuit. And it was only a couple of years ago that the Texas Supreme Court clarified that as long as it's not a divorce, it's something pertaining to child support, possession and access, that sort of thing, you can have a binding pre-suit mediated settlement agreement. So you could go to mediation and you can have an agreement, and then based on that agreement, you could get a new court order. And so if the other side has a case of where they've changed their mind, they don't want to do that, you have something binding that's irrevocable that prevents them from doing it. And in the meantime, you want to do COBRA, I mean, that's just That's just a financial question that people are going to have to ask themselves. But, you know, depending upon the cost of medical care, I mean, maybe COBRA is not such a bad idea. But from a legal perspective, if the sides are in agreement, then there are a couple of different ways procedurally to really expedite getting a new court order. Now, if the parents are not in agreement, then what you do is you just have to file an action and ask for something called temporary orders. And that's one of sort of the unique things about family law, is that a lot of family law cases have a phase in the very beginning of the case that's called temporary orders. And it's basically like having a trial date in the first 60 days, because a lot of what happens in temporary orders has such a huge impact on the rest of the case. And so there's something else. And I had that happen once where we had to get certain stuff paid into a trust immediately because it just hadn't been done right. And so got some of that accomplished via temporary orders.
We have a question. It says, if you're given a large amount of money from a division of assets, sale of a house, etc., and you're divorced, where do you put that money so it doesn't jeopardize your ability to get state benefits? And that is a slippery slope. And the reason I say that is because basically, if your child is a minor, you can have one house, you can have one car, and no more than $2,000 assets in your name. And so you really wouldn't put those assets in a special needs trust because they're your assets, not your child's. And you wouldn't put them in an ABLE account. You know, you can only put $16,000 a year in an ABLE account, but once again, they're your assets, not the child. So in that example, if you reinvest the money in a house, so you have one house and you have one car and less than $2,000 assets in your name, your child is under age 18, then they will qualify for SSI and Medicaid through the Social Security Administration. But there are such things as your kids qualifying for Medicaid, like under the MDCP waiver, the medically dependent fragile children, whatever the waiver is. But the bottom line is they don't look at your income for that Medicaid qualification and assets. They look at the child. So it's kind of a different, depending on what type of Medicaid you have, depends on that. So yours is slippery, but the bottom line is there's really no place other than one house. You can own one house. So if you went and sunk the money into the house, paid cash for a house or something like that, then that wouldn't necessarily be used against you. So complicated. But so Mike, we're going to keep moving because we got about less than 15 minutes left. So talk to us about, I'm going to go back here, forward. Talk to us about the guideline child support.
Right. So the way it works in Texas is that you apply what's called guideline child support to the first like $9,200 or so after taxes, net resources, effectively on a monthly basis. And if you have a child with special needs, but maybe they don't meet the statutory definition because their disability is such that maybe they'll be capable of self-support in the future, they just have additional expenses now, then you could use that as a basis to ask for above guideline child support. And the way it works in that scenario is that if the obligor makes above that threshold of effectively after-tax dollars of $9,200, then you look to, first you calculate what the child's quote unquote proven needs are, and then you allocate the guidelines to that first $9,200, and then the remainder of after that, you look to the child's proven needs and you allocate between the two parents. However, if a parent makes less than that threshold, right? If 100% of their income is below that, and you're looking at just say paying 20% for one child or 25% for two children, and I'm assuming that there are no children from a prior relationship, because those, or a new relationship for that matter, somebody gets remarried and they have a child from that second marriage, then you're paying slightly less. It goes from like 20% to 17.5%, that sort of thing. So if you're in that type of situation, then it's 154.123 That's the Texas Family Code section that deals with above guideline child support for people who do not exceed the cap on income. And there are 17 different statutory factors. I won't go through all of them, but basically the legislature came up with a way that says use common sense and the children's best interest in 17 different ways. And you use all of that to kind of factor in for the child. I will say that the case law is very uniform, though, on one particular point, and that is that above guideline child support is not to be used for lifestyle. It's not to be used for the lifestyle of the child. It's not to be used for the lifestyle of the obligee. It must be used because of the child's needs. Give you an example: private school tuition.
Did you say 154, 123? I'm putting that the section of the law 154.123.
Yes, ma'am.
Okay.
And so classic example is private school tuition, right? If you can prove that private school is a need, then you can show that you need above guideline child support for that. If it's a lifestyle choice, though, if you just want your kid to get the very best, but the law doesn't require somebody to pay that. And I'll give you one of the few cases that have really gone into that, although it's not a special needs case. Dad was French, mom was American. There was one private school in Dallas that was a French immersion school, and the mom's French wasn't very good. And so dad didn't want to have to pay the private school tuition at the only French immersion school in Dallas. But mom said, no, this is a need, because if the child doesn't know French, then the child's never going to have a connection as good as she could have had with the father's family. And she just can't get that at any other school in Dallas. And she needs to be connected with the father's side of the family because this divorce has been hard, and the trial court agreed, and the Dallas Court of Appeals affirmed. They said that in that particular case, private school tuition is a need. If you do have a child with special needs, and they need to go to a particular school, then I think in that situation, you have a need and not a lifestyle. And so whether someone's making above the income cap or not, you have some factors there that link the payment of the tuition to the child's need and not lifestyle. And that's essential.
So okay, so I'm glad you brought the private school up, because and obviously if you have proof that the child was not thriving in the public school and the private school is necessary, and we've seen people through the district and get the district to pay for private, blah blah blah. We've seen all that. But what about caregivers? And I know that this was especially true during COVID, with kids with compromised immune systems and things like that. But what if is it considered, medically necessary caregiving services, attendant services, respite services? Is that something that could be considered in the calculation?
It could be. You have to prove that it's a need. And going back to one of the first slides where it says get your team together, and the third potential expert was a medical expert. That's really where, now you don't have to have testimony from a medical expert. A parent's testimony will suffice. But then a lot of times you're going to be in a he said, she said type situation. And so what I've seen in close call cases is that if you have a well-respected expert, say in the field of autism, for example, and they say that, yes, this child is disabled, or that this child is disabled and needs certain needs, then, and this is the way that those needs can be accommodated, then that can be addressed that way. And that's how you would do that. And, and I know I've talked a lot about what do you do in court, and I know that most cases don't go to court, and I know pretty much nobody ever wants to go to court. But the reason why I reference it so frequently is that when you're going through the litigation process, even if you have the best of intentions, both sides are well-intentioned, both sides have good lawyers. In the decision-making process, people are going to look at what their best day in court is and their worst day in court, right? And they're going to try to negotiate between those two categories, right? And sometimes people just make a decision like, yeah, you know what, that person's probably not going to get that in court, but I want to do that anyways, right? And people do that. But that's why you always have to kind of look to the case law or to the statute or what might happen at trial, because that will have an absolutely instrumental role in the negotiations and leading up to mediation and what happens at mediation. Because sometimes mediation takes forever, right? You're there from 9 in the morning to 7, 8 o'clock at night. And I generally don't like to be there past dinner time. I say, let's come back if we can. Although sometimes that doesn't happen. And so, because it's really kind of the mediator's call. But you're there for a long time. And the mediator, to get a side moving, is like, you're probably not going to get this in court. Or flip side, the other side's probably going to get this in court. So why aren't you conceding this point, right? It's a tool in the mediator's toolbox to try to facilitate a settlement so people can reach a deal and not have to go to trial.
And I think that this is important. I mean, and yes, mediation can be long, but litigation can take years. Like, it can be a lot of years and lots of money, lots of stress. But I think that, when you said it's kind of going back to the team, there goes your team again on the mediation process of kind of coming up with what's fair and in the best interest, considering the fact that you have a special needs loved one. I think that those are all important. And then, is there a such thing, Mike, as mediators that are nuanced and special needs? Because, when a mediator comes in and sits down and says, well, this is the law, this is the family law, this is the child support law, and, they start saying these things emphatically and they have no background in special needs. What do you say to families that might enter into that situation where?
Well, I would say that that's really the role of your lawyer. I mean, are there mediators that understand special needs statutes? Yes, there are. But what you really need is you need a lawyer that understands it, because what the lawyer can do just about any mediator is put it in a memo, have a conversation prior to mediation that says, these are our concerns. This is where we think we meet the statute or don't meet the statute. And that's really the lawyer's job. I know we're running low on time, Allison. There's one thing, and it's in the slide in a little bit, that I just wanted to draw everyone's attention to, because we've talked a lot about child support, but also normally in a divorce situation, possession and access of the children terminates when the child turns 18, and child support terminates when the child turns 18 and graduates from high school. We've talked a lot about how child support can be extended beyond the age of 18 and graduating from high school. But what a lot of people don't realize, because it is in the child support statute, but for an adult disabled child, you can have possession and access governed by a family court. And that's important, because sometimes people will want to move because they want to move to a state that's got greater services for their child, or they just have to move for whatever reason. I mean, people are taking care of their adult children with special needs, and they're getting into a phase in life where they need to retire, or they need their family support group to help them, and maybe a lot of their family is out of state or what have you. And so possession and access can be decided by the family court, and this is one of the few areas in the law where there's explicit overlap with the probate court if there's a guardianship. So you could go to a probate court for possession and access issues, or you could go to a family court. And the question is, well, how would you decide? And I'll just say generally that probate courts don't like to get into possession and access under the family code. They would, as a general proposition, I've heard judges say that they would just defer. I'm not talking about a specific judge, I'm speaking generally, that they would just defer to the family court, right? Because if you think about it, the family court is equipped to handle these sorts of issues because they handle them on a pretty much a daily basis, right? Whereas that is not what you're dealing with on a daily basis in probate court.
That makes a lot of sense. And so, and those some of those things may be discussed with guardianship, and depending on who the guardian is, and if there's dual guardianship and that kind of things. I know that we have run out of time, but again, you guys are going to get a copy of these slides, and I want to get So you had talked about a lot of the stuff you talked about already. We just didn't go through all the slides, the family law practice manual. But so here's Mike's contact information. You can reach out to him directly. So if you are on this journey, you've already hired somebody, you need to hire somebody, you need to hire somebody to partner with who you've hired. You can reach out to Mike and you can kind of talk to him more personally about your situation, and then you guys can go from there. But I would just like to say that there is hope, there is light at the end of the tunnel. It is a pretty stressful time if you're in this, if you're not getting paid, child support got cut off, or medical insurance is no longer being paid. I mean, there's all kinds of things that come up over the years in this. So whether you're just kind of dipping your toe in, checking out, getting a divorce, or you've kind of been down this trail for a while, I feel you. And it does get better. There is light at the end of the tunnel, but I think that the key, and you said it multiple times, is to really have your team. You got to have your team. And I know, you know, Mary Ann Hughes in the greater Houston area, she is not an attorney, but she has done a lot of consulting and has got a lot of tips, and you know, she's got a website and everything. You can check her out. But she can definitely help in kind of pointing and directing and things like that. And then of course, Mike is definitely nuanced and special needs. So I'm sorry you guys are going through whatever you're going through that brought you here today to the meeting. But Mike, I am appreciative of you taking the time to partner with us to get this information out there. So guys, again, if you guys have any questions, just reach out directly to Mike. I know we're out of time for today, but if you need us, we're the financial side of the house. We're not the legal side. We're the special needs planning. We're your questions on SSI and Medicaid. We're your future care cost estimate. We're nationally certified as Social Security advisors and members of the Special Needs Planning Academy, so we can definitely help you as well. And our consultations, our initial consultations, are always free. So all of our past webinars live on our YouTube channel. This will live out there too today. So if you, you know, we have webinars on a weekly basis on a variety of special needs planning and transitioning topics. You name it, it's out there. So you can check out our YouTube channel for free. There's no cost to subscribe, and look, check out any other webinars that might be relevant to you and the journey that you're on right now. So thanks so much, everybody. It's been a pleasure, Mike, and we look forward to partnering with you again soon.
Thank you, Allison.
Take care, everybody. Bye now.